On the broader question of fee diversion, I also agree it is really important to fully fund the office. The office is fully funded by user fees. Those fees should be used for the activities of the office for the benefit of those users.
Thank you, Mr. Iancu, and thank you for being a great partner, Chairman Grassley, in seeking answers to a wide range of questions over a number of topics over many years. Thank you to the panel, and congratulations on your nomination.
I'm going to go back to Mr. Iancu. You have to give advice to the President and Secretary of Commerce, basically, I suppose, on intellectual property policy. But you also advise federal departments and agencies. If confirmed, what recommendations, maybe the answer to this question, you haven't been there yet, but if you got an answer to it, I'd appreciate it. What recommendations would you make to the President of Congress to improve the state of intellectual property in the United States and abroad?
I would focus on the top-level issues that I mentioned in my opening remarks to begin with. First and foremost, evangelize the IP system. Promote the brilliance of inventors, the excitement of invention, and the great benefits it brings to the economy and to society in general. I think a concerted effort can be made by the administration and by Congress and leaders in that regard. I would also, to the extent possible, work with the rest of the administration and strengthen intellectual property rights in the sense that return to a higher level of predictability of the IP system. On the international front, I look forward, if confirmed, to work with the rest of the administration and the USTR, for example, to insist that our trade partners have strong corresponding IP laws that protect American companies doing business overseas, and that there are appropriate enforcement mechanisms for doing such business overseas.
Okay. Also, there are a number of important offices that deal with intellectual property, copyright, the Office of U.S. Trade Representative, maybe others. They all play an important role in making U.S. intellectual property that make sure that it's protected here and abroad. Would you pledge to coordinate with your government counterparts to bolster U.S. intellectual property rights and enforcement?
I do, Senator.
In your opinion, what is the proper role of your directorship in the PTAB adjudication of cases?
The director is a statutory member of the PTAB. I don't know for a fact whether my predecessors acted as sitting administrative patent judges on the board, but that is an option under the statute.
So I presume what you're saying is you're going to explore your participation after you get there.
Correct. If confirmed, I will explore the feasibility of that, and frankly the desirability of doing that, balancing all the various other duties of the position.
Okay. A number of industry stakeholders have complained that abusive litigation by patent assertion entities, patent trolls is the name I go by for them, continues to be a significant problem. Your opinion on the issue, and if you believe there is abuse, how would you think the problem should be addressed?
Mr. Chairman, any abuse of the IP system, and frankly any system, should not be tolerated. It is important to have a well-functioning, balanced IP system, and Congress, as well as the courts, over the past several years, have taken a number of measures to address some of that abuse. And to a large extent, we should see how that recent development in the case law and some of the recent acts of Congress are working out, and take stock of that and see whether more needs to be done. And I emphasized at the beginning, and I do as part of this as well, that as we do that, a balance is critically important. We really do have to be careful, as they say, not to throw out the baby with the bathwater.
In the Invents Act, Congress created the inter-parties review. You've already used that point, and also post-grant review proceedings, as the law says, for quick and cost-effective alternatives to litigation. As Senator Coons mentioned, a number of industry stakeholders are concerned that IPRs and PGRs are being abused to the detriment of patent rights. As you're aware, Congress specifically noted that these processes were, quote, not to be used as tools for harassment or means to prevent market entry through repeated litigation and administrative attacks on the validity of a patent, end of quote. Do you believe that the way the American Invents Act has been implemented fulfills those policy goals? And if you don't agree that it fulfills them, what changes should be implemented to improve the process and ensure that it meets congressional intent?
Senator, as I've mentioned, we do have quite a bit of experience now with the IPR process. There is quite a bit of criticism out there about some of its provisions. In fact, there was a Supreme Court hearing earlier this week about the constitutionality of the entire IPR process. And if confirmed, it will be one of my priorities to work with senior leadership at the Patent Office, Congress, and the interested stakeholders in the IP community to identify the specific issues that need to be addressed and how to address them. Some examples were mentioned by Senator Coons, but they do include to take a look at and see if anything needs to be done, the amendment process in the IPR system, the standard for claim construction, the type of evidence that is admitted at the hearing itself, how the IPR consideration is determined at the top of the proceedings, and things along those natures, and based on the experience that we have to date, make appropriate decisions.
My last question. The constitutionality of post-issue American Invents Act reviews before the PTAB has been challenged and is being considered by the U.S. Supreme Court in the Oil States case. Can you tell us what your views are on the constitutionality of PTAB's post-issue review of patents?
Well, Mr. Chairman, that issue was heard at the Supreme Court just 2 days ago. I would not presume to prejudge what the justices will have to say.
Okay. I think I'll have a number of other questions for answer in writing. And I think you heard me say that there'll be 1 week for you to receive answers in writing. And Mr. Rodriguez, you should be warned that your job on the bench is going to be more difficult than your hearing.
Thank you.
Hearing is adjourned.
Thank you.